Due process of law is one of those majestic, important, but very difficult to define terms that appears twice in the Constitution. It appears in the Fifth Amendment and applies to the national government, and it appears in the 14th Amendment, which applies to the state governments. In the context of law enforcement, by and large, what it means is we have to treat criminal defendants fairly. We have to give them notice of charges that are brought against them. We have to give them an opportunity to defend themselves. We typically have to give them all sorts of other procedural protections, like the ability to subpoena witnesses in their favor and bring them into court. We have to have an impartial magistrate, impartial jury. Now, some of these specific protections appear elsewhere in the Constitution as well. For example, a lot of the trial protections appear in the Sixth Amendment. But the general concept of due process of law applies very much in the criminal context, and it's been used on a number of occasions to invalidate various things the police have done.
Defining due process is very difficult. Really, due process is similar to the beauty is in the eye of the beholder concept. That is, really, the Due Process Clause means whatever a majority of the members of the Supreme Court say it means at any given time, and they can change their minds from time to time. In the late 19th century, what it meant was protecting people from economic regulation. You couldn't have minimum wage, you couldn't have maximum hours, working conditions, sort of things, because that violated people's basic right to freedom of contract. In the 20th century, it got much more into personal rights, like the right to privacy, like the right to abortion, the right to use birth control, the right to marry. And today, it's probably being used in equal protection and due process are being used in areas like same-sex marriage and the rights of transgender people. So it really evolves with society. And that's really appropriate if you think about the Constitution and what effect it should have on society. That is, there's no great moral claim that the views of a group of people that met in 1789 and 1791 should govern our lives today. And if the meaning of the Constitution were static, then I think there would be much more of a need to amend the Constitution or even have a new constitutional convention. But the meaning of the Constitution evolves over time, and so more contemporary understandings of what are fundamental rights are brought into the constitutional meaning through the clauses like the Due Process Clause and the Equal Protection Clause, clauses that are vaguer, that aren't very specific about the structure and organization of the government. And so you get this sort of more contemporary understanding of what rights people ought to have. And that applies also in the law enforcement context, where what might not have been considered an excessive punishment 200 years ago is now considered an excessive punishment, or what might not have considered a privacy right 200 years ago is now considered a privacy right. And so it's clauses like the Due Process Clause and other vague constitutional provisions allow for the sort of evolution of our understanding of rights and lets our Constitution stay fresh and relevant to a current situation.
In the context of the Fifth Amendment, as I explain due process to police officers, it means that an encounter between the state and the citizen must be transparent. It must be they must be consistent. It must reflect consistency. It must be fair. The citizen should have an understanding of what's happening to him or her. The citizen should have an opportunity to defend him or herself, to respond to the encounter. And I think when an encounter is marked by those characteristics, there has been due process of law. It has been orderly. It has been pursuant to a scheme. It has not been capricious, and it has not been arbitrary.
So the Due Process Clause of the Fifth Amendment is a constitutional articulation of our collective idea of fairness. So if the Constitution, at least constitutional criminal law, means anything, it means that a system of justice should be fair. So oftentimes people equate due process with a concept called fundamental fairness. And fundamental fairness exists on two registers. The first register is called substantive due process. That means the thing is actually fair, substantively. that the process was not so corrupted that a person did not get a fair hearing, a fair trial. The second register is procedural due process. Procedural due process means that there are these processes, like a trial, like preliminary hearings, like all of the sorts of things that lead up to a substantive determination of guilt or acquittal. And that if there is a problem with the procedural due process as well, then that is a violation of the Constitution. Because the notion goes that it's difficult to ascertain truth in some absolute metaphysical sense. That is to say, it's difficult to ascertain the truth in some absolute metaphysical sense. So we get at our notions of truth through processes which we think are fair processes. Now, there are many ways you can get at the truth. There was a time in American history where we did things like weight people's feet, put them in a well, and say, if they drown, God is telling us that they were guilty. If they're innocent, God will save them. That's one method of ascertaining the truth. Not my particular chosen method, but that's one method. Another way is to engage in all of these safeguards at trial. And the analysis is that it might not get to absolute truth all the time, but it's going to be pretty close. If you do A, B, C, and D, and you do them properly, then we're going to weed out the injustice. So that's the notion of procedural due process. So the implication is that if you don't follow the procedures, then there's something unjust about the eventual conviction.
Substantive due process is the guarantee that you will not be treated in a certain way, that certain things won't happen to you. For example, I have a substantive due process right to bodily integrity. The state can't come along and chop off my hand. Doesn't make a difference why the state wants to do that. Doesn't make a difference what procedure the state uses before it decides to chop off my hand. I've got a substantive due process right to be free from excruciating pain, to be free from having my bodily parts amputated. So substantive due process tells the government there are certain things you cannot do, no matter how much you want to do them, no matter how carefully you go about trying to do it.
Well, there are no exceptions to the notion of due process. Due process, like every other term in constitutional law, is interpretive and highly contestatory. So what violates substantive due process? This is a big issue in constitutional law. So the notion is that substantive due process violation will be found where there's something that shocks the conscience, that is so antagonistic to our basic notions of fundamental fairness that it cannot stand. Now, so those are pretty words and flowery words, but the truth is the Supreme Court has not found a substantive violation in many, 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 many decades, right? So the last substantive due process violation is the case that I learned when I was in law school, and a case that I teach now, and it's called Rossman versus California. And it's a case where a person was forcibly brought into a hospital and had their stomach pumped by doctors, but against their will, so that they would regurgitate drugs. And the court said, too much. That shocks the conscience. You can't just haul people in and do things to make them throw up all over the place to get some drugs. There may be more humane ways to do it. One could let nature take its course. Eventually those drugs will come out one way or the other, but to make people throw up or to engage in surgery and cut it out of people's abdomens, that shocks the conscience. But the court hasn't really found much else to have shocked the conscience. Almost all due process cases now fall on a procedural register. And courts, I think, are more apt to deal with procedural rules as opposed to substantive standards. So a standard is something like shocks the conscience, where a rule is something like, did you give the Miranda warnings? Yes, no. You have a much more clear answer.
The basic requirement of due process in law enforcement, of course, is that the law enforcement has to respect whatever rights there are that are spelled out by state and local law and by federal law. So if there's going to be a procedure that's going to go on, then the procedural rights have to be respected. But due process and similar sorts of unclear clauses like unreasonable search and unreasonable seizure, for example, are interpreted to protect against things like excessive force. They're a requirement that government give medical care to people that are in custody, whether it's pre-arrest, after arrest, after conviction, those sorts of rights that are related also to the Eighth Amendment, freedom from cruel and unusual punishment. All of those rights sort of work together to create a system of proper treatment of people in the custody of the government.